Welcome to Judge Echo, where we uncover the most shocking legal battles currently sweeping the USA. Subscribe Judge Echo for daily courtroom updates.
Discovery is complete.
Yes, Your Honor. I met both at the jail last night. We went over the police report. I would ask if we could address bond.
I have a tether violation.
Judge, the only thing is, speaking with my client last night at the jail, is the violation is that she couldn't power up the tether. She's still wearing it. And she was released originally on PR bond with the tether. She had problems charging it. And I believe that's the violation itself. We're asking if the court would please consider just to really restore back to the PR bond. I would ask for without the tether, but if it has to be the tether, if somebody could look at it, she's still wearing it. It doesn't work. So we just need to get that straightened out. For my client, the tether was acting up when she was brought into the jail. So, okay. I just think the tether people have to either come in and adjust it or get a new tether, or hopefully without a tether.
Did she contact the company when the alarm was going off?
Your Honor, I did, but my problem was I couldn't see very well because my contacts, and I accidentally typed in 8100 instead of 8160, and I had my dad look at it, and we both double checked. And he couldn't see it. He put the wrong one, but I did leave 2 messages for Brian Levitt. He told me to charge it for 320, I did 35. I called him after to see what my percentage was. I left him a message. And when it was going off, I called him again, left a message. When it was going off, me and my dad both attempted to call. And my phone was dead, so I couldn't get his number. But
I don't have any of that information regarding any call to the community correction or anything along those lines.
So I had the opportunity to read the community corrections violation report that I believe Your Honor has as well, and that's not sort of like community corrections violation.
I have the sheriff's office report.
I have a bond violation community correction.
I would not have that.
Which I don't have. I don't know what it says, Your Honor, but I'm just asking if the court would please consider a lot.
Well, I got to figure out.
Mr. Levitt, and I can provide the court. Do you want me to email this over?
Yes, if we wouldn't get a chance, that'd be great.
Yes, Mr. Levitt gave her very specific instructions. She was advised to charge it immediately after the corrections, and she was told to, I'm still speaking, she was told to charge it for 2 hours. Mr. Levitt is the person that had to make contact with her while he was sending. He got an alert that the device had low battery. He attempted to contact her on the number that she provided him. That was unsuccessful. He started sending alarms and sirens repeatedly to the advice. Finally, the defendant, finally I should say, is, I'm really bad at math, 6 hours later, the defendant calls from a different phone number. He goes over the instructions with her again and says, I instructed them to charge it for 2 hours. She said she could not charge it for 2 hours. I told her it was her responsibility to keep the device charged and that it was critically low. And that's, excuse me, if it gets critically low, dispatch will be contacted. They acknowledged this and the phone call ended. They then only charged it for 35 minutes. So she was given very clear directions on what to do. That was from June 10th, the first time it being low at 1 a.m. Then June 10th, 7:47 p.m., we received another low battery alert for the defendant. All attempts to reach the defendant were unsuccessful. At 7:40 p.m., dispatch was contacted, advised of the violation, and was asked to have respond to take the defendant into custody. Deputy Mace, who was on scene with the defendant. They were claiming they had been trying to charge the device and were unable. Deputy Mace was told they needed to get arrested on the violation. The defendant had only charged for a total of 45 minutes in the last 5 days. And at 9:05 p.m., the defendant was tracking it to Washington County Jail. So the device is clean. In addition to this, my office just charged her with stalking in a separate case. In addition to this, my office requested a $10,000 cash surety bond at the time of charging this case. This case being today's case, you requested the $10,000 cash surety on what you choose before your honor.
Mr. Kirwan?
I'm keeping the same argument, Your Honor.
Okay. Motion for my introduction is denied. Moved. Can you this matter as you vote?
Judge, just clarification, is the bond $2,000, 10%?
What do you mean? I have 2,010% on this case.
And if she's released, it's on tether?
It's on tether. She'll have the same conditions.
Okay.
What? Oh, no, she is not going to sit there and mouth me. Her bond now is 25,000.
Really?
10%. Yeah, really? You want to keep going? I didn't think so. Have a good day.
25, 10.
Ashley Richards.
Ms. Richards hasn't been testing. What are we going to do on this? She hasn't been testing, and there's a current bench warrant out for her with no bond.
That's correct, Judge. I do have, I had a discussion with Ms. Richards. She had expressed some dissatisfaction with my office in general and me. Specifically, I don't know if she's wishing to ask the court for a new attorney. I do have some information that I can immediately refer to the court, but I didn't want to do that if that's the case, since I wouldn't want to step on a new attorney's toes in terms of what they wanted to do.
And Your Honor, no, regardless of what Ms. Richards' problems are with the public defender, she has failed to report. She's missed several tests starting from February to April 11th, and then was positive on April 17th and April 24th, and she has an active warrant.
As I said, Judge, I have a test as recently as May 2nd that I can provide to the court immediately, along with some other documentation. Again, I just didn't, given the nature of our last conversation, I didn't know quite how to proceed.
Ms. Richards,
Yes.
you haven't been going to testing according to what I have. I've issued a bench warrant out for no bond. You need to turn yourself into the Washington County Jail. I'm not even addressing the attorney issue at this point.
Your Honor,
You have counsel.
Your Honor, as I said, I have a test from as recently as May 2nd from her primary care physician. She is currently in a high-risk pregnancy. I'd ask the court to take that into consideration here. I would have turned those things in, but for the conversation, and I can do that immediately if the court would wish to give us another date. But given the nature of our conversation, I was kind of between a rock and a hard place.
And if Ms. Richards is a high-risk pregnancy, then why is she testing positive for drugs?
Well, I think that would be between her and her physician.
Today is the
I'm sorry, Judge.
Go ahead.
Oh, I was just going to say, this matter has been kind of a little more difficult because she is in Muskegon, and we're here. We did find a testing facility there. There was no sign; it was actually in a law office. We do have some tests directly from her doctor. The crux of this is that there was an offer for use on it in this matter. This matter was actually charged after it occurred before, but it was charged after she successfully completed probation in Muskegon. I have documentation from Catholic Social Services there that indicates that she has been, that she did her primary care and then it has been continuing with aftercare. Studiously. So there's that as well. I don't think it's a matter of her trying to flaunt anything, but just, there's a distance, there's financial issues, there's medical issues, and there's, but
on January go ahead. But I was just going to tell you, on January 26th, I approved that the defendant could test in Muskegon with results to community corrections. I don't have any results. I've been going back and forth. Mr. Getty, all along, and I don't know what her deal with your office, you're the only one that's been keeping her out of jail at this point. We further ordered that she could test in Muskegon. She needed to get the number to us. I signed a specific order that PD's office had done that regarding the modification of the location of her testing. We did that that was in late January. We then come through February still, and I don't have any tests. And she has continued not to test. And then I get a report on March 29th. This is some period in time. I still, at that point, don't have any tests. No tests, no tests, no tests. Again, gave her a break, didn't do it, and then all of a sudden, I get to March 30th, still don't have any tests, she's not here, and they issue a bench warrant. Bench warrant's been out since March 30th. Again, trying to get tests, still don't have any tests, nothing. We've just been continually putting it over. She decides she doesn't want to test. And then I all of a sudden get a test in April that indicates that she's then positive for THC. And then on the 24th of April, that the specimen has been diluted and there's been some adulteration of that specimen test. That was on the April 24th test.
Yes, sir.
Then we were here on April 27th, and I still don't have tests.
Yes, sir. As I said, I do have a test from May 3rd from her physician. I can forward that. I believe I also have tests dating back as far as last year that I received this afternoon. I also have, like I said, a letter from Catholic Social Services. If perhaps, if I'm still on the case, I'd be happy to submit those things. If the court would consider sending this over for Thursday week, which I think is the next preliminary probable cause date, I can certainly send those documents.
Okay, I understand what you're indicating, and you've been trying to make sure to keep her out of jail, to do all of those things. Apparently, she doesn't appreciate that, doesn't appreciate what the court is saying, wants to make her own rules. That's not how it works. So here's what's going to happen. Her bond's revoked. She needs to appear here. She needs to report to the Washington County Jail by 6 p.m. on the 17th of May. That is tomorrow. Otherwise, a bench warrant will issue
Your Honor,
with no bond.
Your Honor, can I say something?
You can say whatever you like.
I am due on June 5th, and they're taking me on May 28th to have my baby. And I have been tested. I have tested since I had that diluted screen.
I don't have any tests.
Your Honor, as I said, I can send those tests to the court. This is a unique situation. Had conversations. Well, anyways, as I said, I didn't want to air. I didn't want to do anything. If there was going to be new counsel, I didn't want to do anything that it's going to do no harm.
Submitted to the judge.
But I'm sorry.
I thought you submitted all those papers to the judge, you and Camille, because I've been working with Camille through your office too.
Okay. As I said, Judge, I can certainly put this together as a package and send it to the court. However, like I said, there have been some issues that have come up. But if I'm going to stand that case, I would request the opportunity to do that. And before we take the drastic step of, well, there's already a bench warrant, but before we, I would just ask for an opportunity to do that and ask the court to extend us to.
I'm going to keep my ruling the same. Her bond's revoked. If you want to send something in, you can send it to Ms. Kirby. I will be more than happy to look at it and reconsider. But I'm not playing by her rules anymore. We're going to play by mine. I've been as lenient as I possibly can, and I'm not going to sit here and be taken advantage of. Defendant's ordered to report to the Washington County Jail 6 p.m. tomorrow. If she doesn't report, that bench warrant goes back out, plain and simple. If you want to submit something before in between time, if you guys patch up your differences and she lets you do that, that's fine. Then I'll look at it and see what I can do. But otherwise, that's my order. That's the order that will stand.
Did you say,
Thank you.
I'm sorry, Judge, just for my clarification, did you say by close of business tomorrow?
She's got to report to the jail by